So first of all, apologies for this late video. I've actually been out all day, so it is now getting into evening here, and I thought rather than try and jump into the next part of my breakdown of the derivative use interview, I might just have a little chat about today's hearing, which for you guys by now would be yesterday's hearing. Still today for me because basically I'm 14 hours ahead of Florida, so this occurred at like 1:30 this morning for me, and yes, I was up to watch it, and I will be getting up at 4 a.m. tomorrow morning to watch the next hearing, which is apparently going to go for 3 hours, so I don't think I'm getting a lot of sleep tonight. But I did want to go through this hearing just briefly and just break it down for those of you who may have missed a few bits here and there, and also just to solidify things in my head at the same time. So first of all, a quick breakdown of who you had in the courtroom. Judge Keith Carston, he is extremely experienced. His area of expertise is case law, basically, and precedent, all that sort of stuff. So, you know, all these motions, he's well and truly capable of dealing with them. He has done some high-profile cases, including the Todd case, which was the case out of Disney, the guy who killed his family and his dog. Now, over on the prosecution, you have Will J, of course, and you have Danielle Pennell, both extremely experienced lawyers. Danielle Pennell also did the Todd case, so she understands how that judge works, I would say, and it also shows you the level of experience that she has. Now, on the defence side, you have Alicia Smith, who's the one with the cool hair. And now I looked her up because she sounded so inexperienced. But she was actually admitted to the bar in 2013. So she's been a lawyer for 12 years. And she was certified as a criminal lawyer in 2019. So 6 years as a certified criminal defence lawyer. With her, I believe they said Alex Johnson. And I didn't look him up, but I gather from what Judge Carson was saying that he is still getting his accreditation as a criminal defence lawyer. You'll have to forgive my voice coming and going in this. I've had a few issues with my asthma today, so I've been getting into the Ventolin, but it's still affecting me a little bit. Okay, so we've covered who are all on both sides of the courtroom, who's on the bench, and of course, you know, the loser in the orange suit, so there's no point in me trying to introduce him to you. You all know, and I'm sorry, they do seem to zoom in on him a little too much. Okay, so let's jump in and just start looking at this, and I'll pause along the way to clarify or give my opinion. That said, there's one thing that you can help me with, and that is in relation to the McKay factors. These are referenced several times, and it seems to be clarified by the judge that basically two things she's claiming in terms of McKay factors are that basically the defence just has to show that they haven't had reasonable time to investigate or litigate the case to get a continuance, which I don't know why she's claiming that, because they've had like 14 months. And she's also claimed that it would be an injustice for Stearns if a continuance was not granted. So I believe that what is being referred to in terms of the McKay factors. But what you can help me out with, I've tried looking them up. I found a case, McKay versus State, but I just can't see how it would be relevant in this case. So maybe I'm spelling it wrong, maybe I'm mishearing. So if you can point me in, if anyone knows what they're talking about there, because I would like to read a bit more on that just for my own interest. So if you can point me in the right direction of that, please do. Okay, so with that said, let's just jump in and have a listen to what happened.
We're on the record, State of Florida versus Stephen Michael Stearns, 2024 CF 632. Appearances for the record, please.
Danielle Pinnell and William J. for the state.
Alicia Smith and Alex Johnson on behalf of Mrs. Stephen Stearns.
Thank you. All right, the court has set this hearing on the defense's motion to continue the suppression hearing, which is currently set for tomorrow afternoon at 2 p.m. Defense, do you wish to present argument with respect to your motion?
Yes, Judge, and defense has provided a copy to the state already.
Now, it could just be because this is just a motions hearing, but I'm just going to comment on this Alicia Smith and the way she is currently addressing the court, because she's going to lose a jury pretty damn quick unless she learns to enunciate what she's saying, to slow down, and basically learn a bit of public speaking. Like I said, it could just be that this is that just because it's a motions hearing, but certainly if this is the way she's going to talk during the trial, the jury have so much to take in, so much to listen to, that if she's just talking too fast and mumbling and not really enunciating what she's saying, they're going to tune out. Of course, that is presuming that she's going to be the lead in the trial and not old Lizzie Borden. But just an observation that I thought was worth making.
You want me to give you a moment to read, Judge, or you want me to?
Just a moment.
Seriously, we don't need them to be zooming in on the back of Stearns' head. He's disgusting enough as it is. We don't need him shoved in our faces.
These highlight the McKay factors.
Essentially, Judge, they all essentially stand for the
I'm
same thing.
familiar with the McKay factors. Thank you.
And the cases that I provided to the court are Botham v. State, 272 Southern 3rd 876, a 50 CA case from 2019, Turner v. State, 311 Southern 3rd 185, a second DCA case from 2020, McKay versus State, first DCA, 504 Southern 2nd 1280 from 1986, and unpublished opinion that only has a Westlaw site so far, Surratt versus State, 2025 Westlaw 1119091 from last week from April of 2025. Chocola versus State, 867 Southern 2nd 129, 50 CA from 2004, and Singer versus State, 286 Southern 3rd 343, a 50 CA from 2019.
This is standard MO for the defence. We've seen it in so many of their motions. Basically, cite as many cases as you possibly can, as many precedents as you possibly can, and hope that one of them sticks. They seem to think that it sounds more impressive if you can cite a whole bunch of cases, or maybe they think that no one's going to actually check up to see if all those cases apply. Maybe they think that by listing all these cases, they can just convince people, oh, well, it applies in all these cases, so it must be right. And to actually state or to say, oh, and unpublished opinion. Since when has unpublished opinion had any weight in a courtroom? Like, what a joke. You need to be actually stating case law, precedents, examples that actually align with what you are asking. And I think from what we've seen, we can be pretty certain that most, if not all, of these cases that she's just stated probably don't actually align all that closely with her argument. It's just this notion of the more cases I can cite, the better, because then it might sound more convincing, which to me, it's a joke. And of course, this is not the courtroom to be doing it in, because as I mentioned, this judge knows case law inside out and back to front. So he's not going to be hoodwinked by someone trying to cite a million different cases as argument.
Essentially, Judge, defense is moving to continue the motion to suppress the set for the tomorrow afternoon. And looking at the Bofo case, it essentially says that in moving for a continuance, defense just has to show that we haven't had a reasonable time to investigate or litigate the case, and that is balanced against the judicial economy and judicial efficiency in the court managing their documents, turning to the McKay factors, as well as the factors that are listed in, I believe, Turner, that looks to a defense suffering an injustice by failing to grant the continuance, as well as if the delay was attributable to the defense or if it was unforeseen.
So, first of all, she's claiming that in one instance, the defence basically just has to show that they haven't had reasonable time to investigate or litigate the case to get a continuance. That's not what this continuance is about. That particular precedent that she's quoting is more about, like, if you just got discovery, if, say, in March of last year, when they'd only had discovery for a few weeks, and the judge went, okay, let's have a hearing now, then they would be within their rights, because they haven't had enough time. But you can't claim, after 14 months, that you haven't had reasonable time to investigate or litigate, and claim that that applies to some secret information that you won't give, meaning that you won't even say how long you've had that information. So how can you even claim that you haven't had enough time to investigate this secret, confidential information if you're not going to disclose it? And then she's adding on to that and saying, basically, because you are obliged to give me a continuance because I don't think I've had enough time to investigate, then this would be an injustice for Stearns. Personally, given her inability to actually give any information, even to the judge, despite her objections, I believe it is stalling tactics. Claiming that you have confidential information that you now need time to investigate. It is so wishy-washy. So trying to make these claims, you can't claim that you haven't had reasonable time if the judge doesn't even know how much time you've had. And you can't claim this lack of reasonable time if you can't show that this is information that you should have actually come across during the discovery process 12, 14 months ago. I mean, she could be basically looking at something that's been in a document that's been on someone's desk for 12 months and going, oh my gosh, this is important. We didn't look at this. Let's ask for a continuance. And telling the judge his job, saying that it would be an injustice to Stearns if a continuance isn't granted, how can you qualify that if you're not going to give the information as to why you need this continuance? How exactly is it going to be an injustice for Stearns? You have to prove that it is an injustice to Stearns. But if it's all top secret, how can you prove that?
Defense would argue that the intention is not to delay the court, isn't to be derelict in our duties. Defense is moving for this continuance based off of, as the court is aware, there is the second case, and preparing for preparing for the motion as well as in preparing the other case for trial. Defense is coming to information that at this time defense is in a position to be able to divulge to the court or in open court.
So your good cause is secret?
Essentially, Judge. Well,
I vote Judge Carson for senator. So brilliant, so succinct. She's waffling on, and she's going on about preparation for the motion and having to prepare for the other case for trial. And, you know, confidential information has come to light while doing this. So she's not even saying that it's new information. She's basically so vague here. For all we know, she could be saying that she was looking at documents for the other trial and spotted something that is suddenly relevant. Which, like I said, she's had all this time for discovery, so she can hardly claim that it's, you know, something super important at the last minute. So for him to turn around and just nail her completely, so your case is essentially secret, he's not buying any of this. She's got such a weak argument, and she's teetering on trying to claim, basically, we've just got so much work to do. We've got 2 cases to prepare for, and we've got all these motions to prepare for. Okay, but, you know, maybe if you hadn't have done 70 plus motions, you might actually be prepared.
I can't in good faith at this time, being that it's still being explored. I don't know which way it's going to go, if it's going to be something that's going to pan out in favor of defense or be able to be something to be utilized in this case. As the court is aware, a death notice has been filed in the second case, and while I'm not arguing specifically as to that case, in that death notice, this case is used as one of the aggravating factors. So a conviction on this case would be one of the aggravating factors the state would potentially be seeking in the death notice in terms of the homicide case. Defense would argue that this information has come to light recently, and we're still in the process of working through it and figuring out if it's something that would or wouldn't be available in this case. If the defense were to go forward with the motion to suppress at this point, potentially would be relitigated depending on the court's ruling on that. In terms of just regular pretrial in the case, we would need to continue the regular pretrial even aside from the motion to suppress hearing, because we did an evidence viewing. We were able to complete the evidence viewing, and the second part of that evidence viewing is scheduled for June 11th with the state in this case. So defense essentially is moving to continue balancing the Botham factors as well as the McKay factors. Defense believes that this isn't a unreasonable request on the court in filing the motion and getting this set for a hearing, and still doing their due diligence in terms of preparing the case otherwise for trial and for the motion to suppress in and of itself.
Right.
She's not very good at giving logical arguments. So she's claiming that one of the reasons he needs to give her a continuance is basically because a conviction in this first case is going to be considered as an aggravating circumstance in the DP case. And she's like, so, and we're still working through new information from that. And then she claims, well, we weren't able to complete evidence viewing. Doesn't give a reason why. And we've scheduled the second part for June. And then you get the busy. We are busy. We've been busy filing this motion to suppress and getting set for hearing and doing our due diligence. So she's essentially saying that we're still doing our due diligence, but we've just been so busy, and it just would be unfair because we've just been so busy. And, you know, if there's a conviction in this case, it's going to affect the other case. So you need to be super lenient with us with this case. But none of that really seems to relate to this confidential information that they've suddenly come across. My translation of what she's saying is that while we've been working on the other case, we came across something amongst discovery, and we're only just looking at it now. That's the way I read it. Something that she doesn't even know if it's going to affect this case. It may or may not affect this case. In other words, we've got something that could be completely irrelevant. We're just going to remind you of how busy we are because we are preparing for 2 cases and we are filing motion after motion after motion, most of which have absolutely no basis in law. So you need to be nice to us because we've got all this extra work on our back. And we're not going to give you the actual reason that we need this continuance because we need to keep it to ourselves because it's so secret. I mean, where is the relevance of saying we haven't had enough time yet to view evidence? They've had 14 months to view evidence. And if they're still working through cases, well, maybe they need to spend less time working on these ridiculous motions. So she's definitely not even arguing her point here. She's gone from arguing that I've got something top secret that I can't even tell you, Judge, to arguing that we're just so busy looking at all this stuff and we're just so behind because we've got so much to do. So if you were actually struggling to understand her argument there, don't feel bad because it wasn't logical, it wasn't linear, and it really didn't appear to apply to the motion. Seems like in terms of giving reasons for applying for the motion, she's going with the same approach as she has done with citing case law. That is to throw in as many reasons as she can think of, regardless of whether or not they are relevant.
So the McKay factors, so we're on the same page, deal with a request to continue the trial. The other factors that you mentioned deal with a request to continue either a trial or a substantive hearing for absence of a critical witness.
So it seems here that he's actually pointing out to her that she's citing case law that doesn't actually apply to this particular thing. He says, so basically you're citing this in terms of to continue a trial. Well, this isn't a trial, is it? So that's wrong. And then he says, or continue either a trial or a substantive hearing due to absence of a critical witness. Well, once again, not trying to continue a trial because this isn't in trial yet. This is just a motion to, well, a motions hearing So I don't know if that necessarily equates to a substantive hearing, maybe, but there's been no mention whatsoever by her of a critical witness. No mention of being unable to get a critical witness. So he's basically saying, these are the things you are claiming, and essentially implying here, you've not shown me how these apply. And of course, it comes down to time again. If it is relating to a critical witness, they've had discovery for over a year. They've had time to identify witnesses. So to turn around and claim that they need this continuance because of otherwise they're going to miss out on this critical witness, it's just ludicrous.
State response?
Yes, Your Honor. The state has not been in receipt of any witness list or any defense discovery in this case. The defendant in this case was arrested on February 29th of 2024. The public defender's office was appointed the next day at initial appearances. The discovery process started after the information was filed on March 11th of 2024. The state responded to the defense's demand for discovery on March 20th, 2024, and discovery has been ongoing.
This is how you make your argument. This is what a logical argument looks like. First of all, she's pointing out that the state hasn't even received any witness lists or disclosure from the defence. So she's showing that the defence are pretty lax in what they're doing. They're not organised. And now she's pointing out the timeline here. Stearns was arrested 29th of February and the public defender was appointed the very next day. Meaning they have been on this case since 1st of March last year. Over a year. And then she points out also that the discovery process began March 11th of last year. And then she says the state responded on March 20th. So she's saying that the request for discovery was made March 11th. The state responded with what they had in terms of discovery and that it's been ongoing. They have continued to provide discovery to the defence. Essentially, she's saying they've had all this time to get their shiz together. They've had discovery pretty much from day one. So there's no reason for them to be claiming that they haven't had adequate preparation time. And this claim of this secretive evidence and this important witness basically is BS because they've had all this time already.
The motions to suppress that are currently set for hearing tomorrow were filed by the defense on February 6th of 2025. There was a motion to close the courtroom on February 28th of 2025. A notice of hearing for the closure of the courtroom was filed February 24th of 2025. Upon the denial of the defense's motion to close the courtroom on March 27th of 2025, the defense filed a notice of hearing for these motions to suppress. So these have been pending hearing since March 27th of 2025. The defense filed the motions to continue. The defense waited approximately almost 2 months, a little 2.5 months to request hearing time. The hearing has been set. The state filed responses to the defendant's motions to suppress on April 8th of 2025. And then I was contacted by defense. We had a discussion about their request to continue these hearings on April 10th, and a written motion to continue was filed on April 14th of 2025.
So she's establishing a few things here. She's basically showing that the motions to suppress were filed on the 6th of February. It took 2.5 months for the defence to even request hearing times. But she also outlines all the other motions that the defence has been making. Basically, without saying it explicitly, she's pointing out how much time they've spent on motions. They've had the time to put in all these motions, and yet they're claiming they haven't had enough time to actually prepare for the motions hearing. She's also pointed out here that the state filed their responses to the motions to suppress on the 8th of April. And then 2 days after that, they were contacted by the defence to discuss a motion to continue. So what is being suggested here is that basically this motion to continue is a response to having seen the filing from the state, which shows how inadequate their motion to suppress is. And there is this unspoken suggestion here that basically they're trying to buy more time because of the response from the state. And then she mentions that the motion was then filed on the 14th. So even they've had well over a week to get more information, and they're still claiming that it's so secretive that they can't say anything just yet. I think part of what she's trying to do here is highlight the fact that even though they contacted the state on the 10th of April, 12 days later, it appears that they've made no progress on what is supposedly something that's so very important and so crucial for the case.
The written motion filed by defense, the state's position is vague. It is unclear whether this information is necessary for a defense, is necessary for the hearing. The motion simply states that it may affect the presentation of evidence. The state has subpoenaed witnesses. We have a significant amount of hearing time scheduled for tomorrow afternoon. The state's prepared to proceed on the motions and is objecting to the motion to continue the suppression hearings.
Thank you.
So she's basically said what I've been saying all along. The motion that was filed by the state is vague and unclear. They're not saying if this information is actually necessary for the defence or for the hearing, or even if it's necessary, because they only say it may be necessary. So she's basically saying here they want to delay things for a possible what if, but they don't know what that what if is. And then she points out that basically they're ready to go. They've got witnesses lined up for tomorrow's hearing. They've subpoenaed witnesses. They are fully prepared. They are ready to go. Basically, Judge, we've done our due diligence. We've done all our preparation as required. We've done what we needed to do in the requisite amount of time. And basically, if the defence has just got this vague motion and they can't explain where they're coming from, then what's the point in delaying, basically. So she's essentially pointing out, just because they're not prepared, we're prepared, it's on them. They haven't given a good reason, so there's no reason to delay.
Any additional argument from the defense?
Yes, Judge, defense would say that this is necessary for the defense, even if the court were to ask ex parte in terms of, to have ex parte hearing in terms of the basis for the motion. I don't believe at this point defense will be able to disclose that information even to the court, even if an ex parte hearing were requested and or granted. It's defense's position that this information is necessary to be explored in terms of the presentation of the evidence or presentation of the case, because it's defense's position that at this time the information is confidential, which is why a witness list hasn't been disclosed, discovery exhibits haven't been disclosed in regards to it, because it's still being looked to and explored. As the state indicated, discovery is ongoing, and as discovery has continued to be ongoing, so has defense's preparation of the case, reviewing of the motions, filing of the motions, preparation of the motion, as well as in preparing this case otherwise for trial. Alongside the homicide case. So it's defense's position that the granting of the continuance in this case would not be an undue burden on the court. I understand the state having subpoenaed witnesses. The day that I found out about the information was the same day we actually happened to have depositions, so I spoke with the state in person about it, and then sent her an email in regards to her position, and then from there filed the motion to continue. And then we got hearing times while I was in trial with Your Honor as another case, and I filed a notice of hearing as to that. Defense has been preparing. Defense is preparing, and it's defense's position that denial of the motion to continue in this case would be an abuse of discretion, and we'd be asking the court to grant the request to continue.
Really? You're going to take shots at the judge before the trial has even begun? She's basically saying here that it would be an abuse of discretion if they weren't granted this continuance. In other words, saying the judge would be abusing his power if he did not give this continuance. Wow. She's not going to be popular with this judge. So she starts by saying that they're unable to disclose info even in an ex parte hearing. So, no, we're not going to go into the judge's chamber and just talk about it like adults and actually say what it is that we've got, because it's confidential. We don't want the state to know what we've got, even though actually legally the state needs to know what you've got. The judge needs to know what you've got if he's going to make a ruling for continuance. And then she's going on with, at this time the info is confidential, which is why we haven't given them a witness list, or we haven't given them discovery. What? By law, you have to give your witness list. You have to provide discovery. You can't just turn around and say it's confidential. Basically, what you're doing there is holding back information from the state and preventing them from doing their job. Although thankfully it sounds like the state is far more organised and far more efficient, so that when it comes to the point where they actually have to get a judge ruling for disclosure and for the witness list, they'll still be ready on time. And basically that's what it is going to come down to. If the defence are going to sit here and say that we're not giving you a witness list yet and we're not going to disclose, we're not going to give you discovery, then the next step for the state is to actually ask the judge to make a ruling that these have to be handed over. It's the law. We're still looking into it. That's a really piss poor excuse, and I'm pretty certain there is nothing in case law anywhere that says if you're still looking into something, you don't have to actually hand it over to the state. And then she's going on again with discovery being ongoing and preparation is ongoing, and we're reviewing motions and filing motions, and we're also preparing for the homicide case. So again, she's basically putting we've just got so much work to do. Poor us. We've got so much work to do, so it's not going to be unfair. It's not going to be fair for us unless you give us a continuance. Well, I'm pretty certain the judge is aware that you have filed 70 or 80 motions for the other case. That's a lot of time spent filing ridiculous motions, most of which are going to be thrown out, when you could have actually been going through witness lists, discovery, all those sorts of things. So it's about how you manage your time. What she doesn't realise is that she's essentially saying here that they've got no idea of time management, and as a result of that, it would be unfair if the judge didn't grant them extra time. Now, I would imagine that it has never once occurred that a judge has granted a continuance based on being told that they were abusing their discretion. Most judges would get a bit annoyed about that, especially when the accusee is basically only giving vague information which you don't know if the case law that they stated actually applies, because they haven't actually told you what they're talking about in the first place. And they're essentially also saying that they don't trust the judge enough for an ex parte hearing. Because that's pretty much what she's saying. Saying she needs to still keep it confidential. So can't even take it into the judge's chambers. Basically, let's just throw out all case law and just now set up a precedent where if you can tell the judge you've got a secret and he's going to be abusing his discretion if he doesn't give you a motion to continue because you've got a secret, yep, that sounds like pretty solid case law to me.
Thanks. Well, the court's in a difficult position evaluating the McKay factors. In this case, the court's going to find that there's been significant time to prepare for these hearings. This case initiated in February of 2024. Motion was filed almost a year later. The matter was set for a hearing in March. 13 months. I'll note that this is on 24 CF 632. While the two cases are related, this does not deal with the homicide case. The court has an inability to make a determination as to the likelihood of prejudice from the denial. The defense apparently is in possession of some information, the nature of that information, the timing of when it was received, whether the defendant played any role in shortening the preparation time. The availability of that discovery is unknown to the court because the defense is unwilling at this point to share any information with the court, even on an ex parte basis, as to this information. Counsel that has been appointed to this case has the requisite skill and experience to try this type of case. Both are either board certified criminal trial experts or in the process of becoming are being certified as a criminal trial expert. The court cannot, from the information presented, make a finding of good cause, and while the defense argues it will be prejudicial, there's been nothing advanced to the court to support that argument. So the defense's motion to continue the motion to suppress tomorrow, scheduled for 2 p.m., is denied. And I'll ask the state to please have their witnesses present and ready to go.
That is possibly one of the politest admonishments I've heard, but that's basically what he's done. He has basically put the defence in their place well and truly. You've had plenty of time to prepare for these hearings. The case was initiated in February of 2024. It took you a year to file this motion, and we can't determine if what you're claiming here is connected to the homicide case without actual knowledge of what the heck you are talking about. We need to know the nature of the info and when it was received, which you haven't told us. We can't actually determine if preparation time was impacted because you're not willing to share any information with us. Meaning, you're not even telling us when you came by this information, if this is new information, or if this is just something you've made up in your head. You're not even saying if it is all that important, because you're only saying it may be. And then, just to really hammer it in, he points out that actually you've got the skills and the experience to try this case. Basically saying you're not acting very professional. You should be doing better than this because you have got the skills and you've got the credentials. But right now you're not showing me that you have. And basically then, from the information given, I can't make a finding of good cause because you've given me nothing. And I can't support a claim, you've given me nothing to support a claim of prejudice. So, no, all this is just gone out the window. You've made absolutely no argument. You've wasted our time. Pull your socks up, do your job right. Let's see you in court tomorrow. And let's be realistic, mentioning that they have the requisite skill and experience isn't just an admonishment. It's a warning, meaning that you need to lift your game because you haven't got any excuse here. You can't claim that you are out of your depth. So, just for the satisfaction of hearing the chains clanking, let's watch Stern's exit, and then I'll just do a quick recap summary thing at the end.
Thank you. Matter set for 3 hours tomorrow at 2 p.m. That will conclude our hearing.
So basically what we've just witnessed is the defence coming in and admitting that they're unprepared for starters without explicitly saying it. They're trying to use this excuse of we've got all these motions, we've got all these things to do. This defence, discovery is still coming in. We're just, we're swamped. We've got 2 cases to do here. And then they also have this complete nothing burger of we have this information which is confidential. We're not even going to tell you, the judge, what this information is, when we came by it, how it even applies. We're going to list a bunch of precedents. We're even going to list somebody's opinion as our argument. And no, actually they don't quite fit, do they? As the judge points out what those particular things actually relate to. And then, having basically said It's a big secret. We're not going to tell you. We're not even going to tell you how it applies when we came by it. We're not even sure if it is actually going to be all that relevant. But we want this continuance. And then just to really try and make their case strong, they basically accuse the judge. You'd be abusing your discretion if you didn't allow this. The state has essentially stepped in and said, we're prepared. We've done all our homework. We disagree with this motion because there's no information being given. And they've also essentially highlighted the defence basically claiming that they need more time. They've basically highlighted how much time the defence has had and highlighted all the time they've wasted on motions and stuff like that, and highlighted the fact that they just have not used their time efficiently. And then we have the judge basically coming in saying, yeah, lift your game. You've actually given a complete nothing burger here. You've wasted our time because you've given us nothing of substance here. We don't even know what you are talking about. We don't even know if this thing that you are not telling us is even relevant. So go get yourself organised. You're in court tomorrow. See you then. Remember, you're meant to be a qualified lawyer. Do your job properly, or else. That's pretty much it in a nutshell. All they've done is make themselves look pretty damn stupid, got themselves off on a bad footing with the judge, and also shown how much more qualified the state team is. So on that note, I'll finish it there. I will be watching the motions hearing. I'll be heading over to watch that in Allegedly Speculating. So she actually has that scheduled already. So if you want to hop over to her channel, you can click on the notification and it'll just give you a reminder of when she's going live with that. And maybe I'll see some of you there in the chat. I'm not sure how chatty I will be at 4 a.m. in the morning, but I'll be at least trying to sound intelligent, maybe. Or I might just be so zoned out that I'm just reading the chat. But I will be certainly heading over to Allegedly's channel and watching this motion hearing, and then I'll probably work through it all in my head tomorrow and try and get out a bit of a summary video later in the day. So on that note, thanks for listening. If you are new, please subscribe to my channel and of course hit the like button and leave a comment below. Thank you, and I'll catch you in the next one.
Times